Chapter 48 Libel. Section 676. Definition. Libel is a malicious defamation, expressed either in printing or writing, or by signs or pictures, and tending either to blacken the memory of one who is dead, or the reputation of one who is alive, and expose him to public hatred, contempt, or ridicule. It also has been defined as a censorious or ridiculous printing, writing, picture or sign, made with a malicious or mischievous intent toward government, magistrates or individuals. Hodges says that any publication not oral, which exposes a person to hatred, contempt, ridicule or obloquy, or tends to injure him in his business or calling, impair his standing in society or cause him to be shunned or avoided by his neighbors, constitutes a libel. Section 677, Gist. Requisites. The gist of this offense is its tendency to provoke retaliation and a breach of the peace. Hence, at common law, the truth of the matter constituting the alleged libel is no defense. Statutory enactments, however, have modified this rule. To render matter defamatory it must tend, either directly or indirectly, to expose a person to contempt, hatred or ridicule. It is also essential that it be published. This may be done by reading it, delivering it, sending it by mail, or by communicating its purport in any other way. Some courts hold that publication be made to a third person. Other courts hold that it is sufficient is made to the person injured by it. Upon this point, it is said that the letter in question is not a libel, because it was not published by the defendant. But it is well settled that the sending of a letter to the party, filled with abusive language, is an indictable offense, because it tends to a breach of the peace. It has, indeed, been a matter of doubt whether the sending of such a letter to another would support an action for a libel, because there is no publication. But the sending of such a letter, without other publication, is clearly an offense of a public nature, and punishable as such, as it tends to create ill blood, and cause a disturbance of the public peace. This is the better view and the one which is supported by the weight of authority. It may be well to observe, however, that the rule is otherwise in civil libel. Malice is an essential element of libel, but actual hatred or ill will toward the person libeled is not essential. In the eye of the law, to publish intentionally defamatory matter is malicious, and the malicious intent may be inferred from the fact of publication. Moreover, actual knowledge of the publication is not essential. Where the defendant was convicted of publishing a libel in a magazine, which purported to be printed by him, and which was sold at his store by his clerk, the higher court held that bare proof of sale in Mr. Armin's, the defendant's, shop, without any proof of privity, knowledge, consent, approbation, or malus animus, in Mr. Armin himself, was sufficient in law to convict him criminally of publishing a libel. Circulating a libelous and untruthful article was held a criminal offense, irrespective of the motives of the accused. And a false, printed article, circulated among voters, charging a member of the grand jury with malfeasance in such public office by protecting the biggest swindler that ever struck the county, was held criminally libelous. It also has been held that a statement in a newspaper charging a county clerk with dishonesty in office, is libelous per se. In New York, however, to establish a criminal libel a malicious intent must be shown. Section 678. Jurisdiction. Where a libel is written in one jurisdiction and published in another, the author may be prosecuted in the latter jurisdiction. The fact that at the time of the publication he is still in the former jurisdiction is immaterial. Where the defendant was indicted in Middlesex in England, for procuring a libel to be published in that county, the court held that the fact that he was in Ireland when it was published, as well as when he wrote it, was immaterial. And where a libel was contained in a newspaper that circulated in Massachusetts, but which was published in a different state, the court held that the author of the libel was subject to criminal prosecution in Massachusetts. The federal courts have no common law criminal jurisdiction of this offense. As said in an early case, the legislative authority of the Union must first make an act a crime, affix a punishment to it, and declare the court that shall have jurisdiction of the offense. In this case the defendant was indicted for libel in publishing that the President and Congress of the United States had secretly voted tribute to Napoleon, and a demurrer to the indictment was sustained. Section 679. Miscellaneous libels. There are various classes of libels which are indictable on grounds other than that of having a tendency to cause a breach of the public peace. Among these are seditious libels, obscene libels and blasphemous libels. Seditious libels are publications which tend to bring the government into contempt, on which tend to expose to hatred, contempt, or ridicule, foreign potentates, ambassadors, etc. Obscene libels consist in the publication of obscene books and pictures. As they tend to shock and corrupt the public morals, they are indictable as common nuisances. Blasphemous libels are publications which maliciously revile Christianity. They are looked upon as an insult to the religious convictions of the public in general, and for this reason they are punishable criminally as common nuisances. Section 680. Privileged communications. A publication may be defamatory and still not be libelous. As said by Bishop, rights and privileges which one doctrine establishes another qualifies, and thus the process goes on through the entire field of our jurisprudence. Circumstances may arise where a duty devolves upon a person to make derogatory statements relative to the character of another. This duty may be a legal, moral or social one. In these cases the derogatory statements are not indictable, provided they do not exceed the duty and no express malice is involved. Where a member of a school district honestly believes that a certain candidate for the position of teacher is incompetent, and, in good faith, writes a letter to the Board of Trustees remonstrating against his appointment, he is not guilty of criminal libel. And where a former employer of a servant or agent is asked for information relative to the employer's character, by a person who contemplates employing him, a derogatory reply, made in good faith, is not indictable. Again, where information derogatory to the character of another is given in good faith to a relative who is about to marry the party whose character is thus assailed, the communication is privileged. Honest and fair public criticisms of literary productions, works of art, dramatic performances, etc., that are publicly set forth, are also allowable. In this class of cases the criticisms are not libelous even though they contain statements which are false in fact, and of a nature injurious to another. It is otherwise, however, if the criticisms are actuated by malice. The above doctrine is also applicable to public speeches and legislative and judicial proceedings. It is to be observed, however, that an abuse of the privilege may render the offender liable. Thus, an attorney who inserts in a pleading libelous matter that is irrelevant, merely to subject the party defamed to ridicule and contempt, may be convicted of libel. And lastly, the law of this country sanctions and upholds the just liberty of the press, and in the administration of the law of libel the courts see to it that this freedom is not impaired. Proper and open discussion in the newspapers of matters which concern the public is encouraged, and, as said by Bishop, though a particular publication is such on its face as the general law of libel prohibits, yet if a suppression of it would be a restraint upon that open discussion of proper subjects which is essential to the liberty of the people, or to any other public or even private right, it cannot be punished criminally. Section 681. Excitement or anger of accused. Excitement or anger of the accused, at the time of making the libelous statement, has been held not a defense unless so great as to amount to temporary insanity.